to the correct and wise provisions that are required to help our children. Give us the grace to understand the nuances of each provision and the experiences that have been had. Bless this committee. Through Jesus Christ we pray. Amen.
Thank you, Julia. We only have one apology for absent today from Minister Dana Morris, so we're expecting most members to be in attendance during the course of the day. Quite a few members I have spoken to, they will be here shortly. And I think we have two members on line. I think Senator Donna Scott Motley and Senator Shireen Golden Campbell. Okay, so we do have a quorum. There are 5 members. Well, first of all, we took a break, and my hope is that we will be able to meet today and tomorrow. But I don't know if we had circulated to members of the House, and not many people indicated that they'll be able to be here tomorrow. The 2 members who are in the House, MP Cuthbert and Buchanan, will you be able to be here tomorrow at 10 o'clock? All right, so we're going to have a difficulty. We'll check further. It means, you see, I was hoping that we would really finish up deliberations and by the end of June, which would be next week, I mean today and tomorrow. But it looked like we may be stretched. And when I spoke to Minister Dixon, quite a few other persons, they do have graduation during the month of June. So we may well have to take a part of July, because we really would like a report to be tabled, to complete the child diversion, and a report to be tabled and any amendments to be dealt with in the new term starting in September. But today, what I was hoping we would have gone straight to the matrix, but my team at the Ministry of Justice said it's appropriate that we should finish the overview of the Act, and once we finish the overview of the Act, we can see where we go with the matrix, either today or the next time. I know the matrix was only circulated earlier this week, so members may not have had the chance to go through. So this morning, without further ado, I'm going to ask the team from the ministry to go through the Act, and if I may ask members, allow them to just complete, and then just reserve your question towards the end. And at the end of it, we will decide if there are no questions, we can have some deliberation as to when we start to consider the matrix, okay? So without further ado, I'm going to ask Ms. Wigan and Ms. Cole-Jarrett to move ahead.
Just to say that Mrs. Cole-Jarrett will continue. We had reached section 9, and so we'll proceed from there.
Morning, committee members. I'll just pick up where we left off the last time. As Mrs. Wigan said, we would have stopped at section 9, so I'm going to move on to reading section 10, and hopefully we get through the entire Act today. So section 10 focuses on protections in relation to child diversion. So 10.1 reads, an admission made, acceptance of responsibility given, or information disclosed for the purposes of child diversion, A, shall be treated as confidential, and B, shall not be admissible in any proceedings before a court or a tribunal. Section 10.2, oh, forgive me, if it is that you're following the overview document, section 10 would start at page 37 of that overview document, but I'm reading from the Act. Section 10.2, a person shall not be compellable in any proceedings before a court or tribunal to disclose any admission, the acceptance of responsibility, or information referred to in subsection 1 or to produce any document that contains the admission, acceptance of responsibility, or information. 10.3, a child's consent to participate in a child diversion program under the Act shall not amount to or be treated as a confession or an admission of guilt for the purposes of any criminal proceedings for a child diversion offense. Section 11. 11.1, notwithstanding the provisions of, well, this one deals with the effect of the child diversion program. So section 11 speaks to the effect of child diversion program. So 11.1 reads, notwithstanding the provisions of any other enactment where a child is referred to a child diversion committee for participation in a child diversion program under this Act, criminal proceedings shall not be instituted or continued during the period of the child's participation in the child diversion program. Subsection 2, where a child completes a child diversion program, A, in the case of a child who has not been charged, the child shall not be charged for the commission of the diversion offense which resulted in the referral for participation in the child diversion program. B, in the case of a child who has been charged, the court shall make an order dismissing the charge. C, in the case of a child who has been convicted but not sentenced, the court shall discontinue the trial of the diversion offense and the trial shall not resume. And D, in the case of a child who has been sentenced, 1, the court shall make a suspended sentence order, and 2, the child shall not be detained in a lockup remand center or a correctional institution. I just want the committee to just remember this is a section based on the discussions we would have had before about taking out the conviction, sentencing, etc. So we can just note that for the matrix discussion. Subsection 3, subject to section 19, where a child fails to complete a child diversion program, A, the referring constable may proceed with charging the child, or B, the court may continue the criminal proceedings in respect of the diversion offense, which formed the basis of the child's referral to the child diversion program, as the case may require. We're on to section 12, which speaks about duty to make reports. So section 12.1 reads, where a child has been referred to a child diversion committee under section 9 for participation in a child diversion program, the child diversion committee shall report to the referring court or the constable, as the case may be, on A, the child's participation in the child diversion program, including the child's conduct and the outcome of that participation. B, the completion by the child of the child diversion program. C, the non-compliance of the child with the child diversion program. And D, the failure of the child to complete the child diversion program. Subsection 2, the child diversion program shall report, the child diversion committee shall report quarterly or otherwise as requested in writing to A, the child diversion office on any matter relating to a child diversion and the discharge of its functions under this Act, and B, the referring court or constable on matters relating to a child referred to the child diversion committee for participation in a child diversion program. Subsection 3, a report by the child diversion committee under this section shall A, be made promptly in writing, B, identify the author of the report and the child or matter to which it relates, C, be kept as part of the records of the child diversion committee, and D, be made and kept in conformity with any prescribed requirements. On to section 13. Section 13 speaks to the ineligibility for child diversion. So 13.1 reads, a child may no longer be eligible to continue in a child diversion program or for participation in a child diversion program if the child commits or attempts to commit any other diversion offense or any other offense within 3 years after the date of the commencement of a child diversion program.
Sandy, though, I mean, rather than just simply reading, though, could you identify some of the concerns of, like in section 12?
Yes.
You see, you had indicated that there could be we just look at just remind the committee that some concerns were expressed in relation to some of these sections, which is on the right-hand side of your overview, okay? So as you go through, just remind the committee members about the concerns, okay? Well, like section 12, you had...
Okay, so the ministry had a concern here, Minister, where it would have said that where a child has been referred to a child diversion program under Section 9 for participation in the program, the Child Diversion Committee shall report to the referring court or the constable as the case may be. We had a concern about the referring constable in that it may not be the case that throughout the process of child diversion, that same constable may be present in the matter, and so we would have suggested that it not be specific to the referring constable. So that was one of the concerns there under Section 12. So, let's pray for your indulgence. We would have also indicated that there's no clear distinction made between non-compliance of the child with the diversion program and the failure of the child to complete the child diversion program. So non-compliance could indicate a partial or limited engagement with the program where the child has taken some steps but has not followed through on all aspects of the program, and non-compliance could also suggest a willful disregard for the program's requirements where failure to complete can arise from various factors, some within or beyond the child's control. And non-compliance can also lead to failure. So under Section 19, failure and non-compliance also has the same consequence. So we were making a comparison between Section 12 and Section 19. So when we're looking at Section 12, we also have to look at Section 19 because then Section 19 would have the same consequence. So whether the child failed or not complied, then they would not be.
Okay.
Right. All right, so I'm going to go back to Section 13. So the ineligibility of the child to participate in a child diversion program. So a child may no longer be eligible to continue in a child diversion program or for participation in a child diversion program if the child commits or attempts to commit another diversion offense or any other offense within 3 years after the date of commencement of a child diversion program. So the ministry would have identified a challenge here in that there is no indication as to the date of commencement. So this is particularly important to clarify, considering that in accordance with Section 13.2, which says that a child shall not be eligible for participation in a child diversion program after 3 referrals to a child diversion program. A child may benefit from up to 3 referrals to a diversion program, and as such, it's assumed that the child can participate in a child diversion program up to 3 times if each referral is acted upon. This could mean that it is possible to have 3 commencement dates, so 1 for each referral. But because we don't know what the commencement date is necessarily, Ms. Clark, sometimes I know if you want to step in here in terms of how it is determined in the program when the commencement date is. Let's go ahead.
Go ahead.
Okay.
So currently we assume that the program has started once the child signs their individualized diversion program.
Right, so we would want that to be clear for the purposes of distinguishing how we then treat the number of referrals when we're counting if the child has maxed out their ability to participate. There's also an issue here in terms of referrals versus participation. So how are we going to count it? So if a child is referred to a child diversion program and the child does not necessarily participate, do you count that? Or is it that you count specifically if the child is referred and participates? So that's something we'd want the committee to consider as well. under section 13. Okay. Right, so that could be a little clearer in the Act, so that's something for the committee to consider. In terms of we can move on to section 14, which talks about the child diversion program itself. So section 14.1, where a child is referred to a child diversion committee for participation in a child diversion program, the child diversion office, on the recommendations of the child diversion committee, shall develop a child diversion program, A, utilizing one or more of the diversion options specified in section 16 as is appropriate in the circumstances, and B, based on the evaluations of the child diversion committee in the particular case of the child having regard to 1, the best interest of the child, 2, the nature and circumstances of the offense or alleged offense, 3, the recommendations, if any, of the referring court or constable, 4, the parent or guardian of the child, 5, the socioeconomic conditions of the child, and 6, the victim or other persons or the community affected by the child's behavior. And I would just want to remind the committee here of the discussion we would have had in the last sitting regarding the child diversion committee versus the child diversion office, and how the referrals are usually, based on the Act, go through the child diversion committee, but technically in practice we do the child diversion office. That's where the process really starts.
All right, could you hold, SG, you wanted to?
Thank you, Chair, and good morning to you and the members of your members and colleagues. I realized that there had been a request for an overview of the Act, and usually in these types of meetings, the overview should have been done maybe by the second or third meeting. And usually the overview is done even before you have submissions, because usually your members would want to understand the context within which they're here, and they're here to review an act. So the overview should have been done long before. I understand it wasn't, and I understand the need for the overview to be done, but I also think this is not the best use of the committee's time, and I am going to make a suggestion. When you're doing the matrix, you will still have to do an overview, meaning when you're doing the matrix and when you are going to, submissions would have been on many clauses, or it's not clauses, sorry, it's an act, sections of the act. So it means usually there is a discussion about the section, and then there would be, you would take the submissions, as in if there are proposals to amend. So I'm suggesting that you just merge both activities just to maximize the time of the members of the committee, because I know the members of the committee have so many things to do. And I also know that you want this joint select committee to wrap up as quickly as possible. So I'm just suggesting that we could start with the matrix, and if there is a section that is not covered by the matrix, then all the ministry team would do is just read out what they're doing now, which is to give an overview of the actual section. Mm-hmm. So if you would start at, if there is no comment on section 1, they could just then inform the committee what section 1 says. And then if there is no comment on section 2, then they could still do the overview and then bring out the comment, do the submissions. I just think that would be a better use of the time of the committee.
I would like to propose to the committee we adopt what the SG is saying. In other words, for this morning, we could go through the matrix up to section 15. So we start with the matrix now. You have completed 14, right? The overview of 14.
Well, I was about to finish part 2 of 14. So I read 14.1, and I was about to read 14.2 and 3 to wrap up on 14.
All right, and then immediately after you do 14, we will go back to the matrix, starting from clause 1, and then we, as SG say, we combine the overview and the matrix from 15 onwards.
We would actually have to start at the definition section, Minister, because we did get
No,
a
that's
number
fine.
of, right.
That's
we did
section
get a
1
number,
or
yes.
2. So just complete your overview of section 14, and then we go to the matrix and go right up to 14, and at 14 we then combine 15 and the matrix, all right?
Noted, Minister. So just to wrap up on section 14, I was at 14.1b. So based on the evaluations of the Child Diversion Committee, in the particular case of the child having regard to, 1, the best interest of the child, 2, the nature and circumstances of the offense or alleged offense, 3, the recommendations, if any, of the referring court or constable, 4, the parent or guardian of the child, 5, the socioeconomic conditions of the child, and 6, the victim or other persons or the community affected by the child's behavior. Subsection 2, the child diversion program developed under subsection 1 shall be in writing stating A, the anticipated duration, commencement date, and schedules or plans relating to the child's participation in the program, including the diversion options comprising a child diversion program. B, the specific terms and conditions of the child diversion program with which the child or the parent or guardian of the child is to comply. C, whether a child diversion program utilizes diversion options requiring the restitution of an object and how the object is to be determined. And D, if the diversion option referred to in section 16(1)(l) or 2 is utilized, whether the necessary consent has been given in accordance with section 17(2)(a). And finally, subsection 3, the Child Diversion Committee shall provide a copy of the Child Diversion Program and any subsequent modification of the Child Diversion Program to the child for whom the Child Diversion Program was developed and to the person referred to in section 9(2)(d) in whose presence the child consented. So that wraps up 14.
Okay, so what we're going to do now, we're going to start with the matrix. I don't know if members either have it on their laptop or I think there are a few hard copies available. I must admit I like the hard copy. Right? So Julia, I think there are some general recommendations which we will start out before we get into the individual section. Is that so? Right. So Julia, can you lead the committee then through the general, and then we go soon after to clause 1, and then when we get to clause 14, we are going to combine both the overview and the matrix. Yeah. No, sir. Take the committee through the general observations.
Yes.
And then committee members, we after each page, or we may need your comments. Okay.
Okay, good morning once again. In looking at the matrix, the comparative matrix on the submissions that the stakeholders would have provided, we have approximately 10 stakeholders who have introduced different general comments or suggestion as to what should be included in the Child Diversion Act. I will start with Free Way Children Foundation, and one of their commentary generally is that they're treating with the closing age consideration. They're strongly recommending that closing age considerations be given to diversion matters.
1 second there.
It's the first page, page 1.
That's part 2. You're reading part 2.
That's part. Okay.
You have gone straight to part 2.
No, so even though it's part 2, it is really one flow. So it's part 2, part 1. So we have the feedback. You're looking at the schedule that has starting with Daniel Barnes, right, among our stakeholders. And so we have comments from Daniel Barnes, Ministry of National Security, Jamaica Coalition for a Healthy Society, Ministry of Education, Office of the Director of Public Prosecutions, the Jamaica Psychological Society, Patricia Johns, who was not present but would have sent in written submission, Michelle McCallow. And then we continue with Fiwi Children Foundation, Hear the Children Cry, Rashid Downer, Jamaica Umbrella Group of Churches, and Shariko. Oh, so let us start with the one that you have then. Yes. So, Daniel Barnes, his submission was quite fulsome.
But this is part one.
General comments is that he's recommending that we consider training, that the school administrators and social workers receive training from the Child Diversion Office on the referral process before exercising referral authority under any expanded provision. He's also supporting that all school-based subcommittee members shall complete training on restorative justice principles and child diversion rights in keeping with the referral process. He also made a recommendation that there should be standardized referral forms, that is, the child diversion referral forms shall be prescribed in keeping with Section 28, subsection 7, and distributed to all authorized referral entities. He also recommended that we should have a digital submission be provided to enable a reduction in administrative burden on the schools and community and organizations. He made a suggestion for interagency coordination, and that would include having a memorandum of understanding between the Ministry of Education, the Ministry of Justice, and CPFSA to formalize roles and responsibilities and information sharing protocols. The Child Diversion Office, he's recommending, should serve as a coordinating body across all entities. Phase 4 of his recommendation is that for implementation, it should be phased. Phase 1, 0 to 6 months training for constables and school resource officers on the expanded referral framework. Phase 2, 6 to 12 months, establish school-based subcommittees in parishes with the highest recorded rates of youth conflict with the law. Let me emphasize that point. Phase 2, there should be a 6 to 12 months period to establish school-based subcommittees in parishes with the highest recorded rates of youth conflict with the law. We do not currently have that, and as I said before, it's a new consideration that he's putting forward. Phase 3, 12 to 24 months, national rollout with a monitoring and evaluation framework assessment, program outcomes. That is Mr. Barnes' first general comment. The Ministry of National Security, their general recommendation is that they're proposing okay. And it is not contradictory to our operations, it is just strengthening it. They're proposing an introduction of structured assessment tools to guide the diversion decisions and support greater consistency in the application of diversion measures. Also, consideration should be given to the introduction of mandatory case management for all children referred to diversion programs, which we currently do not have in that structured format. The framework should be established, let me repeat that. The framework should establish a structured case management and oversight mechanism from the initial point of contact with the justice system. And that is 1 point for national security, for Jamaica Coalition for a Healthy Society. they're recommending that preventative long-term measures need to be taken in order to reduce the incidence of youngsters coming into conflict with the law.
As the Ministry of National Security makes this point to see, I think I would just like to elaborate that we are now putting in place what we call an IECMS system, that's
Integrated
electronic case management system, which will connect up all the different sectors. That is from the police and all offenders. So once an offense has been committed and you start taking material, it's going to be within a case management system. So every offender, that person will be in the IECMS system right up to their release from corrections if they actually get to correction.
Yes.
Fine? And that is what operates in Rwanda, and we're hoping that it will come to Jamaica. They've started the case man. So it will interconnect forensic lab, Ministry of Education in this case, and everything will be there so that the correctional service will be able, with permission from the other agencies, to collect the file, you know, from all the different agencies. And so in the past, what happened now is that once a child has completed, or the move from age 17, if they move from age 17 into adult correctional, the record is lost. They don't get it in the main correctional center. That's my understanding. It cut off from at age 17, but there will be this connection when the system is in place. So what you have said that the ministry is looking at, national security, is timely. It will be incorporated in the IECMS system.
Okay.
Continue.
Right. So for Jamaica Coalition for a Healthy Society, the following proposal: preventative long-term measures need to be taken in order to reduce the incidence of youngsters coming into conflict with the law. One such measure is remedying our dysfunctional family life, which involves prioritization and rewarding healthy family life. Now, whilst it may not be specific instructions of how do we put it into the act, but they're giving a general statement as to how they view the impact and what could happen. So that's just a general statement from them. They also propose that there should be a developed curriculum to enable effective teaching of parenting in schools to support that framework possible. They have also indicated that we should implement policies that support parents in their effort to better guide and raise their children. Again, general principles that they're introducing for us to contemplate. The value of marriage must be taught and modeled to our young persons. Again, a perspective, reports on the child diversion program. They're asking, should be tabled. And now this is something that the committee may want to contemplate whether we should introduce it into the legislation. Should reports be tabled to Parliament at least every 3 years? That is a very targeted recommendation that the Jamaica Coalition for a Healthy Society is putting forward.
But to be fair, we do that every year. Yes. When I do my sectoral, we have an appendix indicating how many persons have been referred to child diversion, the success rate. In fact, if you look at my sectoral presentation, we even have a testimonial from, I think, one of the...
Yes.
But a lot of it is confidential, so we're not going to reveal anything that is, breach confidence. Yes. But we do bring out every year an appendix indicating what happened in the child diversion program. So that is, that suggestion is already done.
Yes. From the Ministry of Education, Skills, Youth, and Information, they have a few recommendations. They're recommending that wherever in the Act there is a reference to any form of suspicion, any reference to suspicion, that we should put a qualifying word there as reasonable before it, in keeping with legal principles. The other recommendation that they're making is for us to cater for a child who is or appears to be suffering from a physical, intellectual, or mental impairment and is found to be in conflict with the law, or who is a child offender. And also for us to indicate or reference the Disabilities Act. Another recommendation is where a child is or appears to be suffering from an intellectual or mental impairment, they are recommending that the child be assessed prior to any action being taken against that child. Another recommendation is that regulations should be developed under the Act requiring every child diversion program to include a mandatory educational continuity assessment. And this assessment should inform a structured reintegration pathway tailored to the child's needs and circumstances. Such a pathway should include reintegration into one of the following: formal secondary education, a skills-based track through the Heart NSTA Trust, or an approved vocational or alternative education program. Embedding educational reintegration as a formal component of diversion would strengthen the rehabilitative intent of the Act and align it to the child justice framework within the National Youth Development and Skills Strategies. A child-centered justice framework was also recommended to be very timely, and also they're indicating that administrative delays can undermine both rehabilitation and the best interest of the child. Therefore, it is recommended that statutory timelines be introduced via regulations for key stages of diversion process, which include referrals. So they're saying that we need to be more targeted with each stage, and to make it explicit, the minimum number of meetings within a specified time frame of the Child Diversion Committee, and consideration for approval of a child diversion program. The Ministry of Education is also of the view that clear procedural timelines would promote efficiency, reduce backlogs, and ensure interventions occur while they remain developmentally relevant. In the absence of such safeguards, they're cautioning us, the rehabilitative impact of diversion may be diluted by undue delay.
May I just say that, to the best of my knowledge, all of this is being done. And this, unfortunately, is one of the problems we have in government. There's not enough interaction between the different agencies doing the same thing. So I'm not saying, and I think Ms. Clark and everybody, we need to find a way as we move forward for the Ministry of Education, the Child Care and Protection area, the Ministry of National Security that deals with institution of young offenders, and the child diversion. All three agencies need to work closer together to let them each know what is happening. And I did speak to Minister Dixon. One of the reasons why we may cancel tomorrow, because she won't be able to be here tomorrow. And we really need the Ministry of Education to assist us as we move forward, so that we break down the firewall between the Ministry of Justice Child Diversion Program and the Child Care and Protection Program, which they're separate, but they interact and overlap. And the same with the Ministry of National Security and the Child Diversion Program. They're different, but they overlap at the edges. They're gray areas, and that is why we need to find out how best that we can work closer together. You know, colleagues, I see the same thing with domestic abuse. You have it in Sissoko, you have it in victim services of the Ministry of Justice, and you also have it in the Ministry of Culture, in the domestic violence program. And it seems to me that all the parties need to work closer rather than in separate compartments. But dealing with the child diversion, colleagues, we need to really work in this program how these three ministries, justice, national security, and education, can work for the benefit of the children who may have behavior problems. Okay? All right, so we bear this in mind because what the Ministry of Education presented here, to the best of my knowledge, most of it is actually being done.
There are some elements, Minister.
All right, continue.
Okay, so that's for the Ministry of Education. On a general point, the Office of the Director of Public Prosecution, I'm hoping that your schedule that you have before you, it is saying the Office of the Director of Public Prosecutions. Oh, good. Yes. They're recommending that diversion should occur at the first court appearance, ideally in the parish court, with the prosecutor applying immediately to prevent delays and aging out.
My understanding, though, from the DPP is that we should not even have the child come to court. My understanding is that if the child has been charged and it comes to the clerk of court or to the DPP, they make a decision to discuss with the attorney or with the guardian of the child that they can go on the child diversion program, because the DPP's position was very clear. Why? The idea is to keep the child away from the court process. So you let the referral comes once the child has been charged, an offense has been committed, and the police, the police can refer directly to child diversion without charging. But maybe it is an offense that is, you know, the police decide to charge. So if the person has been charged and it is within those offenses that can be referred to child diversion, then the DPPs say, let them also be a referral so the child doesn't have to come to court. Where I think this applies is where it may not be one of those offenses for which child diversion is in the act. So it comes to court, and it may well be that the attorney or the guardian of the child say, although it is not within the offenses that normally can be referred to child diversion, they leave it to the court to determine whether or not they can send the child to diversion. To give you a good example, it could be that the child has been found with an ammunition or with a toy gun. You get me? And these are matters which, yes, they're serious in the normal course of event, but it may well be a situation in which the court can say, based on the circumstances, they refer to child diversion. So we need to, Samantha, we need to find a way to put it in the act to make it clear that the DPP can refer to the child diversion office in two instances, where without the child coming to court, they can discuss with the child guardian or attorney, as the case may be, that they can go on a child diversion program. The charge could be dismissed if they complete the child diversion program satisfactorily. If it is not completed satisfactorily, they may well have to come before the court. But also the second stage, where the guardian or the defense counsel may urge the DPP, it is not a child diversion category, an offense for which child diversion is normally referred to. It might be if the child was an adult, it would be a serious offense. But because the child might be 14 or 15, as the case may be, they're found with a gun, they're found, they may have committed a serious offense. But here's a child that the DPP and the Guardian or Defense Council might say a child diversion course of activity may well be appropriate, but because it is a serious offense outside the normal child diversion referrals, then the court can order it, okay? So we need to put that so that the DPP can assist the court in agreeing to the referral of a serious offense for a child, okay?
Yes.
Is that my understanding, colleagues? Yes.
Yes. When we get to section 9, there is something treating with that we're trying to incorporate, and Ms. Eaton would have done something preliminary,
Right.
asking the committee to apply their minds to the concerns raised, if you look at that. So what Minister would have said, it is captured.
Right.
Right.
All right, continue.
So, the Jamaican Psychological Society, they're asking that the act explicitly reference the Data Protection Act of 2020 with mention of relevant sections. Consider sections 4, fair and lawful processing, section 5, purpose limitation, section 10, special categories or sensitive data, and 25 to 27, security of data. They're indicating that these are all applicable to this act and its implementation. Patricia Johns provided a general statement. She indicated that children should not be exempt to harsh punishment when faced with a crime they have committed. If there is to be any real lesson learned and for the child to fully understand the magnitude of his or her actions, harsh punishments should not be overlooked.
The only issue there, this was not a presentation, it was actually a contribution.
Yes.
That we did not ignore. We decided to put it on the matrix because what this contributor is saying, that harsh punishment can be rehabilitative. But I think the general trend of child diversion is to avoid punishment. Not that punishment doesn't work, but we feel that it is best to go through a rehabilitative program, recuperative program, rather than a retributive program. So that although we thank the contributor, the truth of the matter is that I think generally we're moving away from harsh punishment. So we have outlawed corporal punishment, right? We have outlawed, and really and truly, it gives me the opportunity to emphasize that corporal punishment is forbidden, certainly in the schools. It's outlawed in the schools. I mean, I must admit, I used to get caning and a lot of, but the truth of the matter, that is now outlawed. And we hope that in the homes, especially the parents, try another method rather than the whip. Okay? So we're urging corporal punishment really to be reduced and completely eliminated. SG?
Sorry, my comment was on the other comment, the one before that you read. So perhaps when you're finished,
No,
from
go
the
ahead.
Jamaican Psychological Society,
Mm-hmm.
about explicit reference be made to the Data Protection Act. It's not necessary because the DPA applies across. It applies all the time.
Right.
To all laws.
So
and
we
to
don't have to put it
everyone.
in the act?
No, no.
Thank you,
in
SG.
in fact, if you put it in one law, it's going to create a nightmare with statutory interpretation, because why have you put it in one and not the other? So it's similar concept to the Interpretation Act. When we have basic concepts in the Interpretation Act, we try not to put them in different laws unless we want a different kind of meaning and interpretation. So our suggestion from the AGC would be that this is not necessary. And just to comment on the whole thing about harsh punishment, you also have to be careful because we have ratified the CRC, the Convention on the Rights of the Child. We have, Jamaica has obligations under that convention. And so we have to also be very careful when we talk about quote-unquote harsh punishment, because we could then be acting inconsistent with our international obligations.
Okay, thank you very much. I think that should be noted, because this contributor emphasized this harsh punishment, and it is a continuing conversation that when you hear it, don't spoil the child by saving the, right. Spare the rod and spoil the child. I'm not too sure that the strict interpretation of the Bible was meant to be that. The idea is that you need to be able to get our children on the right path. And as SJ has pointed out, we have international obligations now that there must not be corporal punishment of our children. All right. The next section seemed to be straightforward. These are things we're doing. Go ahead. Sorry.
Thank you, Chairman. In relation to Michelle McCullough's
Yes.
contribution, though, much of it is similar to the Ministry of Education.
That is correct. I was thinking that.
And so, yeah, so when I look at it, she's not here to defend herself, and I don't hold brief for her, but I think she's in the right direction in
Absolutely.
terms of the incentive base to
And as I
encourage
said,
the youth. So I just wanted to just add that.
The office will really tell you that
Yes.
is being done now in a way.
That's so.
Thanks.
And so I will not go through Ms. McCullough's
No need.
presentation. Very good. So that is part one. Part two on general, you're now in, okay, perfect. So Fiwi Children Foundation, they proposed, closing age considerations in diversion matters, where an alleged offense arises from consensual conduct between two persons who are both under the age of 21 and the age difference between the parties does not exceed 4 years, diversion officers shall consider whether the matter is more appropriately addressed through counseling, mediation, education programs, or other rehabilitative interventions, rather than formal criminal proceedings. In determining whether the diversion is appropriate in such circumstances, the diversion officers shall have regard to the ages of the parties, the nature and extent of the alleged conduct, and whether the conduct was consensual, the absence or presence of coercion, exploitation, or abuse of authority, and the best interests and the welfare of the child. Generally, they're recommending that we introduce a closing age exception and tiered approach similar to what Trinidad and Tobago provides for.
Sure.
Thank you, Chairman. But since we don't have such a law, right? What is our law doesn't have a closing age. We don't have anything set up like that, so we'd have to make some changes. I mean, I'm in agreement with what she said. And so if it is that we're going to change, I would want to know how then do we
May I just say that
amend?
the reason law reform is aware, there's a submission now that should be coming before Cabinet which is a recommendation from 2017 of this close-in age, which is a 4-year. And in truth, it really, I'm going to make sure that this comes even before we do any change to this. The close-in age will be that it will be decriminalized. Consensual sex between close-in age teenagers, right up to the age, to the best of my knowledge, of 19. So 19, and 15, 19, 16, that's close-in age, consensual. Bear in mind, however, and we must not ignore the Jamaica umbrella for churches do not agree with that provision. They feel that the child diversion should take over. So the issue there is whether or not, if you see it as delinquent behavior, let us say it, you consider it to be delinquent behavior, is that something that should be referred? This is the position of the Jamaica umbrella for churches, that where children, especially young children, are engaging in consensual sex, that they should go through a program of child diversion because oftentimes, bear in mind, colleagues, it is the parents who really refer these matters to the police officers. You understand? And oftentimes, it's the boy who normally gets convicted, So the question, we can't ignore where there's that sort of, should we call it delinquent behavior between young people, where the child diversion could be a course that could be utilized based on the recommendation of the Jamaica umbrella of churches. And also the coalition, I think the coalition for Health to Society also made similar recommendation. Yes, Minister Cuthbert.
I just want to add, I'm torn because I do believe that if it is consensual between two youngsters, that they should not be punished for the rest of their lives and this go on their record. But I'm also, wary of persons with our society that we live in, that persons can be coerced, people can go out there and lie, tell a lie on, or to threaten to say, if you don't say this was consensual, then this is what's going to happen. So I don't know what we can put in place to make sure that we are ruling those things out. I don't know how possible that is, to rule those kind of happenings, to prevent, anything like this from happening. Because I think, just any society, not just Jamaica, these things can happen where persons threaten you to say this was consensual when it wasn't, when it was rape. So again, I'm careful with this. I believe that it shouldn't be, you shouldn't be punished if you're close in age, but you can be coerced, I think. So we need to look at that carefully as well.
Before I allow you, Minister Dalrymple, that is where I think, we need to find a pathway where it is alleged, put it no stronger than that, that there has been consensual sex between youngsters, and even if it's with a close in age, that there's the opportunity to send it to child diversion so that there can be a program of recuperation and to satisfy, because I'm telling you, hear the children cry, umbrella for churches, Health to Society, they feel that the law should remain as is. But I think that from the recommendation of the 2017 report, and generally, the view is, and it will come to Parliament for discussion, that the close in age should be decriminalized. Okay, sorry, Minister.
Thank you very much, Minister. I was brought up in the church. I believe in strong Christian principles. I believe in the institution of marriage. I think it is sacred and correct. But we have to decide. We cannot be focusing on an act for child diversion and wanting to help our children and not be afraid to take a position. And probably because as an attorney and a member of parliament of a deeply rural area, what happens, not most of the time, all the time, the boys are criminalized and the girls are left behind. So when you say we need to not move away from the recommendations of the report or look at the closing age thing, I think it is wrong. I think we have to face the reality and we have to make a decision. Because either it is we want to help our children, which include boys and girls, or we want to keep them as criminals when these things happen. We, as the church in rural Jamaica, where I am the member of parliament, every quarter mile is a church. It's a deeply Christian society. And it does not matter because the children, let's face it, they get to an age and there are biological feelings and things happening between them. There are situations where the girls encourage it. There are situations where the boys encourage it. But never at all do we get a clear picture that girls, once you get it, and half of the cases in South Trelawney are full of that. And the boys that we have, we say our boys are marginalized, they lose out on every opportunity in life. They can't get a farm work card, they can't go forward, it's a criminal record. And I do think that we have reached a point, and this act has been excellent. The ministry has, the education it has back. We must endorse our Christian principles, but we must face reality. We reach a point where we ought not to criminalize our children when you have closing age contact like that. And this is not against the church. I believe in my Christian principles. I believe in marriage. I mean, I've been married twice. I believe in the institution, right? But that does not say that we are going to criminalize our children because they fall short.
I think, colleagues, even from the discussion and from the interaction with the various personnel and groups, that there's a consensus amongst the members that we should go along with that recommendation of the closing age. So, not in spite of the views expressed that I did say from the 2017 report, just a matter that it has not yet been brought to Parliament, that we are going to decriminalize closing age. Even the children's advocate, I think, supported it. There were lots of support for it, but at the same time, I would, if you don't mind, colleagues, just Juliet and Marison, what I would really like to say is that we see it as a form of behavior that could be referred to child diversion. And if it is brought to the police or to the let us say the police, because oftentimes it may well be the parents are reporting it to the police. The police can refer that form of behavior so that the parties can go through that child diversion. So our response at this stage, we are not against the closing age. In fact, we would support the report, but we also believe it is a form of activity that child diversion or Child and Care Protection Act of the Ministry should take into consideration to assist the children to straighten out their lives, okay? All right. Sorry.
Yeah, Chairman, I'm not detaining the committee, but every time we get here, I remember the submission from Senator Golden Campbell. And The
She's
issue,
on, by the way.
yeah, but I don't know if she's
All right,
is listening.
I'll allow her in after you.
Yes, but I
I'm very
want.
much here, MP
All right,
Buchanan.
very well. If I misspeak on your behalf, correct me. But the issue of consent is always it's difficult to get around, and I did have asked the drafters if it's something that we're going to contemplate, because we keep using this thing about this consensual sex when it's a fallacy because they're not capable. Now the closing age where you go 19, who is capable versus some 15 would not be. It's difficult to see how we would be putting that into child diversion in terms of some mandatory form of counseling and the program. So if it's decriminalized, as if I recall correctly, the learned senator would have said that we should be making it appear to be as if they're doing something wrong, but parents also have a duty, and I'll bring up the uncontrollable parents who have a duty to raise your child. And I mean, there was a time that birds and the bees was still out there. I know the internet has taken that out, but how are we using the resources of the government when there's a little bit more technical and serious matters in terms of behavior that we're trying to curb?
Senator Golden, you'd like to come in? Senator Golden?
Yes, Chairman.
Go ahead.
And unlike my colleague, committee member, I'm not apologizing for detaining the committee on this matter because it's a matter that I have raised strongly before, and I am continue to raise it. And I have to say that I find our approach to the matter of the quote-unquote consensual sex between minors unacademic and a little lacking in diligence. And I say that, Chairman, because it's not about our feelings, it's not about how groups feel when they come before us, but the relevant authority has the duty to conduct the kind of research to inform members of the legislature in terms of what pertains, what the data is. And so the question that I would like to ask in relation to this matter, and I will hearken back to my previous submissions on the matter when the Sexual Offences Act was passed in 2008, and I repeat those submissions here. There was not a policy contemplation to criminalize this matter. It wasn't intended to criminalize two minors. It was intended to protect a minor who had consensual sex with an older person, a person of age, right? Consensual, however you may think about it. Now, that really is statutory rape, but it wasn't contemplated that a 15-year-old and a 16-year-old who's at the age of consent would be criminalized. What I would ask you, Chairman, if in the contemplation of this, and I understand you to be taking something to the cabinet, can we be informed at the appropriate time? What's the data behind all of this? How many children are being arrested for this offense? How many of them are prosecuted for this offense? How many of them are experiencing a recidivist trajectory after they're prosecuted for this? When we talk about child diversion, the purpose of the Child Diversion Act, as it's set out in the Act, is to shunt children who come into conflict with the law into a program. And to say you come into the conflict with the law as a 15-year-old or a 14-year-old who has sex by choice, willingly, let me use that language, with another 14 or 15-year-old law, I still can't wrap my mind around it, and I don't understand the policy imperative. What would the child diversion program in that scenario be intended to do? What is it going to convince that 14, 15-year-old child to do? And by the time they come out, by the time the process goes along and they are involved in the program and perhaps get to the age of consent, what's the point of the program at that matter? They're freely legal to do whatever they want to do. I don't understand what we're doing with this. And I join MP Buchanan in his remarks in relation to parents and the duty of parents to teach. And we know that parents are challenged across the country in terms of parenting skills and the ability to parent their children, given the different structures of family that we encounter. But it would seem to me that our approach is not just to talk about whether we're going to take it out or put it in on the basis of how we feel about this matter. I feel very strongly about it, but I want to be guided by the data. I want to be guided by what the policy imperative is intended to achieve, what it is not intended to achieve, and what is the outcome we're looking for. However we treat these children, whether they put them through the child diversion program or something else. It doesn't seem to me we are doing the work that is required here, with respect.
All right, Senator Golden Campbell, let me just tell you that as Minister Dalrymple said, at circuit every term, a significant number of cases involve this children. Boys, no, the boys, I come into your short boat. But you have a situation where, in fact, a number of them have been referred to child diversion. I don't know if Ms. Clark could just give us an indication how many of these cases have been referred to, and what sort of program? What sort of program?
Yeah, what are you teaching them? Are you teaching them not to have sex or not to have sex when they're of a certain age or to ignore the feelings that they have? What are you teaching them?
No, to be fair.
Or they can kiss but they can't have sex? I can't imagine what this program would teach you on a matter like that.
I think the idea is so many of them, we let them concentrate more on their lessons and make sure that they go to schools and engage in extracurricular activities.
And Minister, does that prevent them from having the feelings?
No, I don't think they're doing
that.
that.
We need to get serious about this, we're not serious.
Minister Dalrymple, you wanted to come in again.
Thank you very much. I want to differ greatly with you, Senator Golden, with the greatest of respect. Probably because for my 43 years of practice in rural Jamaica, most of the cases, and when you say data, I don't have data, but I can tell you, if you have 20 cases there, 15 of them are for children who are close in age, who have had sex. And I'm going to tell you, the lives of several of our young boys have come to an end because of this sort of situation. And I disagree when you say what we're having is an on-academic thing. Maybe it is on-academic.
No, but she's just asking for data, though, Minister.
Yes, and I'm responding, Chairman, to say that from my experience as an attorney in rural Jamaica, and I'm saying it because I've done it for 43 years, a lot of children and our boys have lost the opportunities for further education, further advancement. They don't have an opportunity on overseas programs, and they become the boys on the corner that become the criminals that we are passing laws and spending a lot of money in government to rehabilitate. So I don't know, when you ask me, what are you teaching them? What is the program to teach them? I don't quite know how to answer you because, for example, you have children in your own home or own children, and you talk to them and you teach them. When they tell a little fib or they say so and so, when you talk to them and you say, don't tell lies because so and so and so, what is it we're trying to teach them? I ask you that question. I'm trying to hold on to the lives of our young children, particularly our boys, and give them an opportunity not to become tagged as the unwanted criminal in the society because they have dared to have sex. And yes, we talk about the parents who are the parents who have neglect. What do you want us to do about those?
No,
because those parents there are in the homes
Minister
seeing a lot of
Chairman.
things.
Minister Dalrymple, I don't
I'm
think
sorry.
you're disagreeing with Senator Golden, you know.
No, I don't think she is either. I think we're sharing the sentiment. The point I'm making and the singular point I'm making is that neither the minister's sentiment nor my sentiment can form the basis of policy making and legislative drafting. There has to be work done by the appropriate officers in the ministry to look at the data, to look at what the program delivers, to compare it perhaps with what is delivered across different jurisdictions, and to determine whether or not we are looking at a problem, one, that needs to be fixed by a legislative tool, two, whether or not it's a problem that can be fixed by the existing structure we have in the child diversion program, and ultimately, what are we seeking to achieve when a child is shunted there? What outcomes do we wish? So whether it is, I can't make policy on the basis of a significant number. You must know the numbers. You must know what happens to them. And it's not about 43 or 53 or even 110 years of experience. We have to study this thing properly because like the minister says, it impacts the lives of real people, real children.
All right, we're coming back to what Ms. Wright has been waiting for a long time. Go ahead, Ms. Wright.
Okay, good morning, everyone. Earlier in the deliberations, the Jamaica Constabulary Force had given us a table outlining numbers as it relates to the persons between the ages of 12 and 17 arrested for crimes between the years 2020 and 2024. So of significance, there were 4 crimes that I highlighted that had the highest numbers. So I'll start with the highest one being assault, OB harm. Over the period, it was 142 children. The next was actually sexual intercourse with persons under the age of 16. So that saw 129 people, well, children being arrested.
What percentage is that?
I don't have the percentage. But after that, Minister, I'll just let me finish. Grievous sexual assault was next with 121, and there were some significant contributions made by JFJ as it related to this particular crime. And then the last one was rape, 105. But what was also interesting, so we have the second highest arrests were made for the very section we're discussing in the Sexual Offences Act. What was interesting coming from JFJ as well, which perhaps could help Member Golding, is where it said their analysis and data that they received in relation to our ministry's child diversion program is they had, the years they had were different from what the ministry, they captured March 2020 to January 2024, I believe. And out of 1,517 referrals, 690 children had successfully completed the program, with about 62% of the completed matters out of the ministry at that time came from the sexual intercourse with persons under the age of 16. So it was 62. So it said, among completed cases, sexual offenses, particularly consensual sexual intercourse with persons under 16, account for the majority of completed cases, which was 62%.
I'm sorry. I need to understand. Does that mean that that the persons who were arrested for consensual sex is 62%?
We don't know.
Or just the persons who were arrested for sexual offenses?
The persons who would have entered into the program, right? So a number of persons would have entered into the program with the Ministry for Child Diversion at a particular time, which I believe is January, up to January 2024. It was completed cases had 62% of children being successfully completing their diversion for that particular offense. The data that the constabulary force has given us, though, just simply shows the amount of children who would have been arrested, which is a high number in comparison to other offenses. As I said, it's 129 children that would have been over the 4-year period.
Sorry, you wanted to come in? So,
Just
no,
to say to you that
once
our
again,
principal...
Minister Cuthbert, you wanted to come in first?
I wanted to come in and then I will hear what you have to say. I hope I still have my train of thought. There's so many things being said. I think I'm hearing from one end, and I agree, we should not criminalize these children.
I think there's a general consensus.
Right, that's a general. I just feel
Yes.
we should not criminalize these children. But I also am hearing that there's no need for the child diversion
This is where there's
for these children. You know, again, listening to or reading what the Ministry of Education said, and I think there are some other groups who mention intervention with the family. You have to look at, when you look at the Jamaica scenario, you have to look at the family structure. You have to look at the community that some of these children are coming from. You have to look at the exposure to sex with these children if we're going to speak and speak fairly. We have to look at the one-room situation where children are sharing one bed. My God, I shared one bed with 4 people, but they were all females. You know, my grandmother, my sister. And so, you know, you have to look at the dynamics of these families and where they're coming from and the exposure that they're getting. And so the intervention that we should be talking about, again, is to look at what the Ministry of Education talk about, the family, and then have that kind of intervention, get the case managers to go in, and so diversion will work. When you get the case managers to go in to find out exactly what is happening in communities, what is happening with this family, why they are, you know, exposed to sex so early. And so I don't have a problem with the child diversion when it comes to, you know, children having sex.
Right.
And so, again, we should just not criminalize this, and I would say do the child diversion, you know, implement the child diversion even for this act.
Well, one of the things that you can't ignore what Senator Golden Campbell is saying. You're trying, if you refer to child diversion, there's a consensus that we must not criminalize it. But the question is, do we just leave it? As you will recall, the umbrella group of churches, Coalition of Health Society, felt that we can't just criminalize and leave it. When I urged them that we could send these children to child diversion, Senator Golden point, though, cannot be ignored. You're asking children who want to engage their natural urges, and if it's consensual, what is going to stop them? Truth of the matter, Senator Golden, is that oftentimes, as Minister Cuthbert say, they may well be in a situation where they engage it because they are living, you know, with families who are taking advantage of them or allowing them not to concentrate on other activities. But I just wanted to find out from Ms. Clark, these cases that have been referred to child diversion over the years, what approach do the officers take in these matters?
So, Mr. Chair, the approach is similar to any other approach. So once a child comes to the program, we conduct an assessment, and while we are aware of the matter that they were sent for in terms of the sexual and reproductive health, we will help them in terms of emotional regulation, sexual education, consent, what the law says. Safe sex as well, sexual and reproductive health. But outside of that, we also offer them a suite of other interventions that can benefit them as well. So if the child comes to us and they were experiencing trauma, the family is having issues, we also expose them to family counseling, individual psychotherapy, mentorship, if needs be, and they need to be referred to the National Council on Drug Abuse. Whatever the risk factor is that we identify, we try to intercept those risks so they don't reoffend, while also educating them about safe sex.
So you see, Senator Golden Campbell, the point is that when we make these referrals and why I say child diversion can assist. We deal with youngsters who have been referred because they're engaged with drugs, smoking marijuana, taking, these Molly, and so on. So once they're referred, they might want to do it, but we, in a sense, indicate the dangers of doing it. Even the consensual sex, you really explain to them in child diversion some of the dangers and how it can affect and the possibility of early pregnancy, etc. So I don't have a difficulty, colleagues, to say while we recommend decriminalizing, we also say that in appropriate cases where the matter has been referred to the police the police could refer some of them for child diversion, because child diversion officers have had to deal with it at the moment, and to the extent that they can be assisted, because as Ms. Wright said from the JCF report, all of these cases, you have a great success rate in terms of going straight. Go ahead.
Thank you, Minister. I had failed to also say that the issue that our department would have, and I think most people, when you think about it further, if sexual intercourse with persons under the age of 16 is decriminalized, I'm trying to figure out what legal method would there be to get them into child diversion, because child diversion has certain parameters, one of which, the biggest, is you're in conflict with the law. So once no crime has been committed, Minister, it is hard to envision how you are then going to, track these children into the program. So I've heard Ms. Clark mention, all of the things that they do to assist these children. Is it that can be replicated for CPFSA to do? Because what then I would envision is, even though it is decriminalized from a best interest perspective, it would perhaps need a referral to CPFSA for children being in need of care and protection. And so the good work that is being done by the Child Diversion Office in terms of how the programs are structured could then be replicated into CPFSA to assist these children, despite the fact that this is no longer a criminal offense.
Colleagues, this is where I have been struggling from day one with. My struggle from day one has been, why do we wait until an offense has been committed? And I've felt all along we should have a category, call it delinquent behavior. And when delinquent behavior can be dealt with either by the Child and Child Care and Protection Act, which is the Ministry of Education, or in appropriate cases, it can be dealt with by child diversion. I have been saying this is a gray area. And I've always felt, because of the success of child diversion, we could shift some of these before it becomes an offense, before the child. Let us take drug offenses, for example, not even consensual sex, but drug offenses. Yes, it might be immediately a criminal offense, but there are some offenses, like, say, alcoholism, which is not necessarily an offense. But if a parent has a child 16, 17, and every evening they're drunk, this is a delinquent behavior which I think could be assisted by child diversion. So I'm saying you need that category of delinquent behavior where a police officer, I had said guidance counselor, or even a parent can take it to the police officer. I can't control this child. Every evening he's drunk. And therefore, this is a matter that really and truly he needs psychological support, mentorship, to get him away from this delinquent behavior. And I'm saying, this is where that gray area, some of it should be collapsed to child diversion. You know, we have had that discussion repeatedly in the office. What category of delinquent behavior could be captured by mentors, psychological support, and not wait until these children commit an offense, right? So, colleagues, we want to finish this area of the discussion by saying we are decriminalizing consensual behavior, consensual sex, but we would like to put it into that broad category of delinquent behavior so that it can be referred to child diversion. Sorry,
Chairman, before we exit the topic, the GSA is often attached to the sex with a person under the age of 10. Are we there with GSA as well? The grievous sexual assault.
Remind people what GSA is.
The grievous sexual assault. So it is the
well, it is standalone.
no, it's not rape, but it is the digits and the objects that.
To be fair, GSA would be an offense in itself. It's not consensual.
But then for child diversion, which is why I didn't want to just exit the conversation, and I know you can take it there right after, but it's important to note that a part of the children experimenting, and excuse me for just trying to be...
Understand.
A child who is experimenting and they're doing the kissing and the touching, it seems almost ludicrous to have the young child again be exposed to 15 years for digits, fingers, I'll go as far as the tongue, and then say, but it's not consensual by how it's formulated in the legislation.
Ms. Wright, you want to respond?
Right, so I think what member is alluding to is I don't want to say the nonsense, but under the first schedule, sexual intercourse with a person under the age of 16 is divertible. But because of the serious nature of grievous sexual assault, it was never placed in the schedule. And so those are matters that a judge would, in their discretion, have to refer.
That's a sort of offense.
Right, because...
that a court may well have to refer.
Right, there has been recommendations, I know, definitely from Jamaicans for Justice, where they had asked for that matter to be placed in the first schedule. I don't know if the committee members would be minded to view it that way, or simply the presence in the act of a court having discretion to treat with certain offenses that would have been considered more serious than others, because the original policy behind child diversion was minor offenses. The fact that the sexual intercourse with a person under the age of 16 formed a part of the schedule was because of a pilot that was being done with CISOCA, CPFSA, CDA at that time, that was treating with those matters. That is how it ended up in the first schedule. That particular, more serious, because if you think of sex with a person under the age of 16, it's not minor, but it ended up in the first schedule because of a pilot that was being done and because of the numbers, which is reflected in the data that I've shown. So it would be a matter for the members to decide whether they would want grievous sexual assault to be a part of the first schedule and to be divertible from the police or prosecutor, if that change is made, or the court, continued for the court, or if you just leave it as a serious offense where a child would, perhaps through prosecutor, or if they ended up before the court, could then be diverted.
Chairman, this is big shoes and decisions that we have to make. And I know the Minister of State can testify to this in terms of going to court. And even a situation where a child is brought before a police officer and the officer says, you had sex with her, and he says, no, sir, all I do was my finger. And he's in the same situation. And I'm not justifying conduct, but a part of the delinquents that you speak of is that children are experimenting, and I don't think that the legislation ever contemplated a 12-year-old and a 13-year-old experimenting and exposing a young boy to 15 years for digits and experimentation.
All right,
and so if we're treating sex with a person under the age of 16, not contemplated for minors, we have to treat it, GSA for minors, in the same category and take it one step further to say that the struggle with consent that I'm speaking of is they don't have that ability. So we can't say let's not treat them as children for the GSA in relation to children, and we just have to really contemplate that, because it cannot escape my mind that you're in a worse position from experimenting, from kissing and touching and using your fingers to the big step, which is intercourse. It's an absurdity that we have to address.
Right. So it's a matter for the committee. It's a matter for the committee to decide. Maybe you want, rather than put in grievous sexual assault, you just put sexual assault. And then, if it's grievous, the court could decide.
The grievous is going to be medical and the jurisdiction of the court. And I'm saying there can be a determination similar to, well, no, it's a good question because I'm thinking, because there is a distinction between rape and having sex with a person under the age of 16. But there has to be a mechanism where the GSA in relation to minors is experimental, unless it is so absurd that there's also some bodily harm that comes with it.
That's
and the aggression. But I understand, but how do we treat it with children is something that we have to contemplate. And before I stop, the one thing I would say to you is that restorative justice never leaves my mind. I don't see any harm in a restorative justice component being attached to, rather than calling it diversion. But when we do have delinquent children, the format of restorative justice seems to me that you bring in the parents, you bring in that community support, the pastor, and the counselors who are there, and there is a process for counseling. I don't know what it looks like, but I know that the answer seems to be where it is. I always push for mandatory diversion and mandatory restorative justice in light of even the mediation amendments that is coming to us, the Mediation Act. It would seem to me that would be good to tag on to this act before we close, to ensure that when we come into delinquent minors, there is a place that's not necessarily CPSFA.
Well, I think, colleagues, you could see where Member Buchanan is going. In a sense, he really, and I support him totally, that for children, the less you refer them to the court system, the better. Which is what child diversion is all about. Yes, Ms. Ryan.
Just one more thing. It's kind of preemptive because we've only just started general recommendations, but as the discussions are taking place, the members will also have the opportunity, once they're taken through, that there have been recommendations where you do a tiered approach in terms of offenses that you consider minor and you'd leave those for the police. Then you could perhaps have another tier where it's more serious, or not as serious as, say, rape and murder and those things, where a prosecutor could be the one or whatever. So later on, I think, once we're taken through the matrix, you'll see where there are also recommendations as it relates to a schedule of offenses, not just the first one, and it's tiered.
I think we're jumping ahead of ourselves because some further recommendations will come. So can we proceed? Sorry, you... Go ahead.
All right, so Minister, two things quickly. So we are also in support of the idea for the grievous sexual assault to be included in the schedule, because the courts have mentioned to us on a number of occasions that they believe that it would be better for the children to prevent them from coming through the court in and of itself and allow the police to divert.
Absolutely. I agree with
Outside of that, I want us to... I'm trying to formulate the words. Let us consider the roles that we all play. So the Child Protection and Family Services Agency, while there is what they call the lacuna and we have to treat with some matters for them, child diversion is for children in conflict with the law. And if we are not careful, we can crumble under the pressure. Because what I find happening, some of the officers are reporting that the matters for uncontrollable are becoming a larger number in the parishes. And what you'll find happening is that if they're not compliant, there's nothing to hold them to the program. One, it will affect our statistics overall to say that, okay, if a child decides that I don't want to be a part of the program, I was an uncontrollable, I didn't commit an offense. So when we're considering for the sexual intercourse with a person under 16, I would love for us to be very clear in terms of if it's a matter that CPFSA will treat with, when and where. And if it's a matter for the children who come into conflict with the law and we're treating with, when and where. Because when we're in that lacuna, it can pose a problem for us in child diversion because we're not outfitted like our colleagues to be able to manage some of those
But to be
things.
fair, Ms. Clark, all child diversion cases, the consent of the offender, so-called offender, is needed. They wouldn't go into child diversion unless they consent to go. Isn't that so?
So
we don't force them into child diversion. We
no,
give
not
them
the
opportunity.
offender, but the victim also has to consent to say
Right.
they are in agreement with the, and that is where restorative justice comes in at some point to explain what is happening and so on, so they have a better understanding of what is happening.
Right, but I would say that one of the main reasons, if I may put it that, for the success is that these so-called offenders actually agree to participate.
Yes.
Because unless they consent, you don't take them in. Right?
But for the matters that are considered for uncontrollable, they don't necessarily have to consent. The parents will tell the court that they want, or the court will say to them, you have to do this program. But then if they're not willing to do it, and it doesn't present an opportunity for a better future, then it's a challenge for us.
And, you know, colleagues, my understanding from what Ms. Clark has outlined is that the uncontrolled, so-called uncontrollable children, they have committed no offense, but the court feel that child diversion is really an opportunity to assist these youngsters. And the success rate is less than the norm because these children have not consented. But because the court feel that this is an opportunity, we have succeeded with a few of them, but many of them just resist the program. And it is something that we try to overcome by cajoling and not coercing sometimes to be a part of the program. But it is something we need to look at carefully. Could you just say, we don't have a tag for you, say it.
Good morning, Mr. Chair. Good morning, everyone. My name is Kimberly Blackwood-Martin from the CPFSA.
Good.
This is my colleague, Jana Harris, also
from the CPFSA. I'm glad you're here. Yeah.
So I just heard Ms. Clark's statements regarding the uncontrollable children, which currently we put them under Section 24, and we call them now children with behavioral issues. What we're aiming to do now is we're aiming to have therapeutic centers, right? Both residential and non-residential therapeutic centers, so that these children, children who are deemed under Section 24 as being children having behavioral issues, what we would do, we would cater for them in a more fulfilling and substantial way. And so it is, I agree with the multi-agency approach, which is to work together and not to work in different vacuums, because technically some of the work may interlap, but the aim at this moment is to have the therapeutic centers, and so that is the goal for the CPFSA at the moment, to have these therapeutic centers, both residential and non-residential, so that it may take some time. It is in the works. I'm not saying it's an immediate thing right now, but currently that is what we are working on for children with behavioral issues, so that they can be diverted from the very beginning, or to prevent them from the start from even committing offenses where we see that, you know, it may develop into something of that nature. So parents can have a recourse to the CPFSA in terms of that. So that is what we're working on. As I said, it is in the making. It is not an immediate thing. It takes time, but that's how we intend to treat with these issues.
Remind of your name again.
Kimberly Blackwood-Martin.
All right, Ms. Martin, I hope you will rejoin us as we move. I know I spoke to Minister Dixon. I didn't know you were here, I must admit. She said that because we want CPFSA to work closely so that, you know, that sort of gray area, we reduce the gray area as so what children are sent to CPS as against the child diversion, okay?
Certainly.
Because you have heard me talking about that gray area.
Yes.
All right? And obviously when the therapeutic centers are operating, then it reduces the burden on the child diversion officers, because at the moment we have had to increase the number of child diversion officers because of the number of children that are being sent by the courts appropriately to child diversion. And so we need to work together closely. Okay,
Certainly,
thanks again.
Minister.
We're going to move on. We have diverted a lot, so go ahead.
Okay, as we wrap up this part of the discussion, just to remind the committee that in our first submission we would have given some statistics as it relates to the sexual offenses. We do agree that we could update it. We had provided information up to 2024 January to say that for children under the diversion program in relation to sexual offenses, 495 came before the program then. So I know Senator Golden is asking us for empirical data to inform our decisions. We will provide some additional information. As it relates, Minister would have alluded to it, that whilst we speak to the closing age, we heard from Feel With Children Foundation, the Jamaica Umbrella Group of Churches, Minister would have indicated is not in support. Also hear the children cry. Will you permit me to not go into detail on that and continue? Okay, very good. We have comments, not on closing age now, from Rashid Downer, member, Youth Voice, I should say. Young people should not only be subjects of diversion, we should partner in shaping it. So they're recommending a youth advisory panel connected to the Ministry of Justice or the Parliament to be in place to provide ongoing feedback on how diversion programs operate, including the youth perspective as it relates to these matters for diversion, so as to increase legitimacy and relevance. They are recommending that there should be a structured mentorship diversion program, which is formally linked to the National Youth Service initiatives, skills training institutions, apprenticeship, and entrepreneurial activities or programs, community volunteer networks, structured mentorship by positive male and female role models, including professionals and trained community leaders, should be mandatory components. Nation building, they are saying, requires a guided exposure to this, to opportunity. They also recommend the need for us to integrate civic education and leadership development. They indicate that diversion should include civic responsibility training, constitutional education, and community engagement projects. Children must understand not only that their actions have consequences, but that they are stakeholders in Jamaica's development. A child who participates in structured community service connected to national priorities, environmental protection, literacy, drives, elderly care, begins to see themselves as a contributor rather than an outsider. So they say once children are involved in environmental protection activities and literacy engagements, even taking care of the elderly, then they begin to see themselves as contributors and a part of the society and not alien to it. They're also recommending the strengthening of the mental health and trauma-informed care. They indicate nation building must address trauma. Many children in conflict with the law experience violence, neglect, and/or instability. Comprehensive psychological assessments and accessible counseling services must be standardized within diversion frameworks. Healing young minds strengthen national resilience. They recommend that diversion cannot succeed without adequate funding. They indicate that there should be clear indication in the Act as to budget allocation, professional training for diversion officers, and measurable outcomes. This would include reduction in reoffending rates, educational re-engagement, employment placement, community reintegration success. Transparent reporting builds public confidence thereof that view and shows that diversion is a smart investment in public safety. Rashid lastly indicates a young person who completes a diversion program must be able to move forward without permanent stigma. Confidentiality, protections, and reintegration protocols are essential. True second chances require structural support, not just good intention. That is from Rashid, and I believe one last person, Sharika Lindsay. She's asking the committee to consider the implementation of public education and awareness initiatives to encourage support for children returning from diversion programs and discourage stigmatization and discrimination. That covers the general on both schedules.
Okay, so you're moving now to sections.
The interpretation. Yes. Interpretation. Free Children Foundation, their first recommendation speaks to
What page are you on?
page 7 on the schedule that starts with Free Children Foundation. Are we there?
Okay.
Okay, right. So there's focusing on acceptance of responsibility that has been recurring throughout our submissions and presentations, the issue of acceptance of responsibility. Free Children Foundation recommends that reform of provisions that require a child to accept responsibility for a diversion offense prior to acceptance into the child diversion program, notably the following sections make provisions for the said acceptance of responsibilities. Sections 2.1, sections 2.3, sections 2.4, and section 9.2. Would you like me to remind you of that section, or should proceed?
Go ahead.
Remind you of the section? Oh, perfect. Which is inconsistent with the section 10.3. So they're saying to us that we need to revisit acceptance of responsibility as it relates to the impact for those sections. They're recommending that the Parliament clarify the legislative language to ensure that the concept of acceptance of responsibility is not interpreted as a guilty plea. They're also recommending that instead of acceptance of responsibility, that we introduce a new term, acknowledgement of responsibility.
Right.
This
is where, Samantha, the draft, we have to, this acceptance of responsibility has given the court a hard time, if I might put it that way. Because the feeling is that acceptance, once the child accepts responsibility, it is a guilty plea, which is the last thing you want. So we need to find a way that when matters actually go to court, which we hope will be far and in between, that the child, if they're to refer to child diversion, they acknowledge, rather than accept responsibility, acknowledge that they may have participated, but it should not be a guilty plea. If they're going to go to child diversion, there should not be a guilty plea. Because if there's a guilty plea, then there's no reason you should be going to child diversion, right? In other words, child diversion, we don't want it to be a part of the sentence, okay? And unfortunately, this is how some courts have interpreted it, that having pleaded guilty, we are going to send you to child diversion like you do probation, which is not what child diversion is. Child diversion is really to see if you can recover from the offense that you admitted that you did, but you go through a program of activity, mentorship, psychological support, and once you complete that program, then the charge is withdrawn, dismissed, as the case may be, okay? So we want to make it clear, Samantha, that once the court or the DPP, the prosecutor, or the police refer a child and the child accept to go to child diversion because they accept that they did something, committed an offense, then it is not they should not be pleading guilty. Yes. They just acknowledge that they have done it in order to go to child diversion. And if they complete the program, that's the end of the matter. But if they don't, then they may well have to go back to court for a case to be tried, okay? All right, continue.
Acknowledgement of responsibility they are proposing. This means a child's genuine recognition of the consequences caused by the conduct of which the child is suspected of or has been accused of committing. An acknowledgement of responsibility may be expressed in any manner, including the following: a verbal or written expression of remorse or empathy towards any person harmed by the conduct, a willingness to participate in a diversion program, an agreement to take steps to ameliorate or repair any harm caused, an indication that the child understands how the conduct was harmful or wrong, without necessarily conceding legal culpability, or active and constructive engagement in any preliminary or intake assessment. Where a child denies or disputes the conditions on or circumstances of their involvement in the conduct giving rise to referral, such denial shall not of itself disqualify the child from participation in the diversion program, where the referral officer, constable, prosecution, court, or diversion committee, as applicable, is otherwise satisfied that the diversion program would be in the best interest of the child and of justice, or be treated as an indication that the child lacks the capacity to benefit from participation in a diversion program. They further indicate, in assessing whether a child has acknowledged the responsibility for the purposes of this act, the following factors shall be considered: the child's age, developmental stage, and any cognitive, psychological, or communication impairment which may impact the child's ability to articulate responsibility. B, the fact that no particular form of words are required, and C, any conduct and engagement indicative of responsibility in addition to any verbal or written expression. Final recommendation, they're looking at the child offender. The definition of child offender under the Act fails to contemplate scenarios where the offender has essentially aged out of the Act. Comparatively, the equivalent act in South Africa extends the definition of child in these circumstances to include a person who is 18 years or older but under the age of 21. They're recommending that this expansion be clearly set out in the Act to prevent the undue denial of access to the child diversion program. That is a submission for Free Children Foundation.
I'm not too sure that members would like to give that consideration. The South African Act goes up to age 21. I think we better stick to under 18. Because it would affect so many of our other laws. In other words, the child diversion refer to children under 18, 17 and under. What is being recommended by Free Children Foundation is that we should adopt what is in South Africa, where the definition of a child is extended to age 21.
Chairman, I think the only issue is about the date of the commission of the offense. So if it is that the person was a child when the offense was committed, there has to be a conversation as to how long we extend the benefit. So I looked at the act, and I don't see it goes any higher than the commencement date of the offense. If we identify that, if the child was 17 at the time, then they should be given the benefit.
The date of the offense.
At the date of the offense, because it answers our delay issue with the court in any event. So in the event that the child was delinquent or the diversion didn't work out, they go back to the court. But the opportunity to benefit from child diversion is at the date of the offense.
No problem. 17 and under. Okay. Continue.
Jamaicans for Justice, they have a position as well as it relates to acceptance of responsibility. They indicate acceptance of responsibility means accepting responsibility for an offense without a formal admission of guilt or involvement. So they're emphasizing that it should not be a formal admission of guilt or involvement. The the Children's Advocate, I'm trying to identify the other parties who had an issue with the acceptance of responsibility. The Children's Advocate, I believe, had also raised that point until I come upon it.
Okay.
So the Jamaica Constabulary Force, on another matter, child offender, they are asking us to look at it and to give consideration to amending the definition to expressly refer to a child who is more than 12 years old. To expressly refer to a child who is more than 12 years old.
I think generally we understand a child to be over 12. Yes. Exactly.
Yes. That is their recommending. So, I'm going to leave Minister Daniel Barnes.
SG.
The Child Care and Protection Act makes it clear about the age of criminal responsibility.
Quite.
So it doesn't need to be repeated in this law.
That is correct.
You don't need to make any distinctions. And I don't know if you'll recall when we had what was called the Juveniles Act, and when we moved from the Juveniles Act to the Child Care and Protection Act, we tried to take out a lot of the different age ranges because there were issues when you had, for instance, the young, they had age ranges from like, I think 12 to 14, 14 to...
That is correct.
And then there were issues about how you deal with, say, a 15-year-old, like a 13-year-old that they thought should go into another age range. And it also wasn't quite consistent with the Convention on the Rights of the Child. So we tried to remove a lot of the age ranges and the different treatment to different children.
And the different tiers. Right.
I think it's left in just a few situations where it's deemed necessary and also was seen to be consistent with the Convention on the Rights of the Child.
So,
but I don't think you need to put any of this here.
Agreed, SG. So 12 to 17 we consider to be a child for this act.
Daniel Barnes,
what section are we doing?
That's page 5 of part 2.
Part 2 or Part 1?
Part 2, page 5.
Part 1 is Part 1. Part 1.
Part 1?
Yeah.
Okay. Part 1, starting with Daniel Barnes, and Part 2 will start with Fluid Children Foundation.
Right.
Okay. Mr. Barnes has quite a few recommendations for the interpretation section. He's asking us to look at Section 2 to include a Section 2A to read, notwithstanding any provision of this act or any other enactment, a child shall not be considered for referral to a child diversion program, nor shall criminal proceedings be instituted in respect of an offense under Section 10 or 13 of the Sexual Offenses Act, where both parties to the alleged offense are children. The age difference between the parties does not exceed 2 years.
Well, we have agreed on 4 years, so we don't need to.
So we'll, okay, very good.
Yeah. In fact, I think we've dealt with most of what he has,
Okay, perfect. So we move on to the Ministry of National Security and Peace.
4 years.
It is recommended that Rule 177A be consulted to ensure that the terminology is aligned and consistent across the relevant legislative instruments. For Section 2.5, the consent of the victim ought not to be determinative. That is very important. Consideration may be given to rephrasing the definition of child diversion to more explicitly reflect the principles of restorative justice, rehabilitation, and reintegration. They're also asking us to look at expanding the definition of conflict with the law to ensure that it captures not only children who have already been taken into custody, detained, or charged, but also those who are dealt with through early intervention mechanisms such as warnings, cautions, summons, or referrals to diversion prior to charge.
This is where we overlap with CPFSA.
Okay.
So I can imagine this would be more for CPFSA than for child diversion.
For our Ministry of Justice and Constitutional Affairs, we had quite a few to say on the matter of acceptance of responsibility. We're asking that we explicitly indicate that acceptance of responsibility does not require the child to enter a guilty plea. In relation to Section 2.3b and Section 9.2, the two provisions that are provided are to be reconciled and consideration be given to indicating that any child who is suspected of, charged with, or has committed a diversion offense and accepts responsibility shall be considered for admission to a child diversion program, provided that all the conditions in Section 9.2 are satisfied. We should also consider including in the definition acceptance of responsibility or guiding principles and essential elements that capture the essence of acceptance of responsibility without being overly prescriptive. We're asking the committee to consider provisions in the Act that provide additional standards and guidance on how acceptance of responsibility must be explained, communicated, and obtained from the child. To consider the implementation of a requirement that any acceptance of responsibility or consent must be preceded by a verified confirmation of understanding. And the last, Section 24B2 could reference best interest practices under Section 2, subsection 2G for emphasis. That's for the Ministry of Justice. The Ministry of Education also look at the definition for child diversion. We're back to page 5. The Ministry of Education is suggesting that the definition of child diversion be revised in order to take into account the actual intent of the legislation. In the alternative, where the current definition is maintained, the ministry is recommending that a definition and/or clarification be provided for the terms child appropriate process and formal adjudication. They are also recommending that the definition for child diversion be revisited to remove the words suspected of, accused of, charged, or in subsection AI of the definition. The ministry also recommend the deletion of the matter of acceptance of responsibility for a diversion offense as set out in subsection 4 at A2. They're also recommending that we look at conflict with the law. The ministry recommends that an insertion of the terms reasonable suspected of, accused of a diversion offense to the current definition. The definition would therefore read, in relation to a child means a child who is reasonably suspected of, accused of a diversion offense taken into the custody of a constable on reasonable suspicion of having committed a diversion offense, or detained or charged with a diversion offense. As it relates to the best interest of the child, the ministry is recommending that the best interest of the child, the factors be expanded to include factors that are related to child diversion. They're recommending the following to assist in the drafting of such factors: that we're to take into account, in taking into account the best interest of the child in relation to child diversion, every child is entitled to enhanced procedural protections and to be treated in a manner that is appropriate to their age and ensures that their rights are fully respected, and every child must, as far as practicable, be given the opportunity to meaningfully participate in any proceedings that affect him or her. They also recommend that in relation to section 2.3b, acceptance of responsibility, the term acceptance of responsibility as used is also used throughout the Act. However, there is no definition as to what constitutes acceptance of responsibility. So they're recommending that we define the term acceptance of responsibility.
Yeah, we have gone through that over and over, so we need to clarify.
As it relates to section 2.3, the Ministry of Education is of the view that the principles outlined under this subsection need to be expanded to provide further guidance in the approach to child diversion. The ministry recommends the inclusion of the following principles. Parents or other appropriate adults must be able to assist a child at all stages of criminal proceedings and, wherever possible, participate in decisions affecting the child. All consequences arising from the commission of an offense must be proportionate to the circumstances of a child and the nature and seriousness of the offense, and the child must not be treated more severely than an adult would be treated in the same circumstances. Children may only be subjected to deprivation of liberty, whether on arrest, remand, or after finding of guilt, as a measure of last resort and for the shortest period of time necessary.
Mm-hmm.
That
That's
completes, the Jamaican Psychological Society. They spoke to the definition of the term child. They're asking that the definition of child in the Act be expanded to include levels of children involved in diversionary activities. Revision of child to mean a person under the age of 18 years. For the purposes of the Act, the child diversion framework is intended to apply to children aged 12 to 17 years. Children under the age of 12 years who are not eligible for the child diversion framework shall fall within the responsibility of CPFSA. Recommendation 2, they're recommending that the Child Diversion Act should expressly state the minimum age of criminal responsibility and the maximum age a child can be criminally responsible.
Remember, as we say, the SGS pointed out, we know the age, 12 to 17.
The third recommendation, subsection 2.3b, the inclusion of the requirement for acceptance of responsibility be developmentally informed and supported by psychological evaluation to ensure capacity and volunteer, I cannot say that word, it is defeating me, sorry. VOLUNTARINESS. No, I'll bite my tongue if I proceed. And that completes no, that's the interpretation for part 1 from those stakeholders. We move on to section 3.
All right, I think it might be an appropriate time to take a break, because otherwise we're going to be losing our members. No, we're going to stop here, and then Julia, we start with the objects of the act when we return. I don't think we're going to continue tomorrow, colleagues, because tomorrow is not many members will be here. So we're going to go straight to next Thursday, the 2nd of July at 10. Not tomorrow, the following Thursday. So we are going to try and confirm with everyone. Those persons who are on here, next Thursday would be convenient. And then I don't know if Senator Golden and Senator Scott Motley, but we will also ask you to confirm with the other members for me. Is Senator Golden, are you still on, and Senator Scott Motley, are you?
I'm still on, and I'm confirming. I did try to be present this morning, but the traffic in Ligoni.
I can imagine. No, I had to go through, I had to pass through. No, I came down I had to make a presentation at the forensic lab this morning before coming down, and it was one massive traffic. And
I just now recognize, Minister, I have to leave 2 hours early.
All right, we're not going to meet tomorrow, okay? We'll meet next Thursday, and then we might have to find 2 additional days in July to complete, early in July. Senator Golden, are you on still?
Yes, I'm here, Minister.
And it's next Thursday at 10, okay?
Next Thursday at 10. Very well,
Okay,
Minister.
thanks, everyone. I mean, this part we're going through a little slowly, but we hope to pick up next week, because we really want to finalize as many of the decisions as possible over the next week, Thursday, and maybe another day or 2, or in the second week of July, if possible. Look at those dates for me, please, Mr. Nash, okay? But next Thursday we confirm. I want to thank the members. I mean, these discussions have been healthy. Oh, the minutes. Only 1 minute is before us now. March 2nd, I think it is. March what? Would you like to confirm? Moved by Mr. Smith and seconded by Member Buchanan, okay? And hopefully next week we'll have some of the other minutes. Members from Ministry of Justice, all the departments, Attorney General Chambers, Ms. Martin, you and your colleague from CPFSA, I hope next Thursday at 10 o'clock is convenient again. Thank you for being with us. And we hope you can join us for the next, I hope we don't have more than another 3 sessions. Yes.
Chairman, I just wish to urge my colleagues, members, to
go
through the matrix. It will be very helpful so that, you know, we can take some of it as read if we're necessary, because a lot of it is repetitive.
Repetitive, yes.
And we did pretty much go through it, and many of us were here. So it's a matter for the members, but it would be helpful
Right.
if we go through the matrix in our
I think what would also be helpful to Julia and Sandy, if there is a repeat, just in the, you really just say, if you're reading, say the Jamaica Coalition of, and this has also been repeated by so-and-so, you know, so we don't have, so we can, you know, expedite. Where there's a similarity in views of the different presenters, you can just say, summarize everything for us, okay? Thanks again, everyone, for being here. And we had a good session, and we look forward next week to continue. Thanks again, and meeting adjourned. Who did the matrix? A good matrix.